Modern society is becoming increasingly connected digitally through advances in technology and socially through denser population centres. The recognition of freedom of information and the instantaneous sharing of that information has led to a necessary reconceptualisation of intellectual property rights and laws which attempt to balance the public desire to be informed with private rights of ownership. The protection of trademarks, as in recognisable signs used to distinguish goods or services dealt with in trade by a person, is one of the oldest and most familiar forms of intellectual property. In a society where brand strength often equals financial gain, trademarks represent an essential part of our economic and social existence. Unsurprisingly, there are a variety of laws that condition the legal validity of trademarks. This video will provide an insight into Section 88 of the Trademarks Act and how it conditions the existence and function of trademarks on the public register. Section 88 concerns an amendment to the Register of Trademarks, which may include cancelling, removing, or imposing a limitation or condition on an officially registered trademark. Such an order can be made on application by an aggrieved person to a prescribed court, which exercises its power under Section 88 discretionarily on any of the following grounds. Any of the grounds of opposition under the Trademarks Act, where an application for trademark was obtained under fraud, false suggestion or misrepresentation, where the circumstances at the time of application of the trademark may lead to deception or confusion, or where an entry into the official register of trademarks was made under fraud or misrepresentation. The rectification of trademarks is concerned with the integrity of the public register and not merely with the respective rights of the parties. Therefore, applications under Section 88 which affect the public register of trademarks must not be made unless the application is also in the public's interest. Some examples of the operation of Section 88 include lack of distinctiveness as a grounds for rectification, where an application for a trademark is contrary to the Trademarks Act. An error on the register must not remain unrectified regardless of why the erroneous registration was made, or where particulars about the trademark were wrongly omitted or incorrectly omitted on the register. However, an order to rectify a trademark on the grounds that it is liable to deceive or confuse may not be granted if it can be shown that the omission did not arise through any act or fault of the owner. Because of this, whether Section 88 is a true discretionary power of the courts, or whether it is limited by the operation of Section 89, is still uncertain at law. Since the industrialization of modern society, trademarks have become powerful tools for the communication and provision of goods and services. The legal conditions that regulate their operation is therefore of paramount concern for our increasingly connected society.